And was that matter concluded?
Yes, it was.
What was the conclusion of that matter?
I spoke to the other attorney, and the other attorney agreed to dismiss the domestic violence protection order against Mr. Price, and that he, the other attorney, would send me documentation to place restraints, typical restraints in a dissolution, and that we would sign agreed orders, but he never did it.
The other attorney?
Yes. So I was able to get the petition dismissed.
Petition was dismissed.
Yes.
So there was a satisfactory resolution to the domestic violence case.
Yes, Your Honor.
That was based on their conference. Well, that was worth something. So far we have 2.5 hours worth of work.
Yes, Your Honor.
Okay, so that's about $610 from $1,500 that you agreed to, that he spent with you.
Yes, Your Honor.
Okay. How many hours did you spend on Mr. Price's case?
More than $1,500 worth, Your Honor. In fact, more than $3,000 worth.
Show me.
I don't have it. I don't have a bill with me, Your Honor.
Why not?
If I may explain. On April 17th of 2013, I was preparing to go to this mandatory settlement conference in Pierce County, Washington. Mr. Price called me on April 17th, left a message. The message was, "I am no longer in need of your services, and I never want to hear from you again." In spite of the fact that he called and left that message.
Just a second. Did you, in fact, send that message?
Yes, Your Honor,
on April
I did.
17th?
On April 17th, yes, Your Honor.
Okay, go ahead.
Okay. In spite of the fact that he did that, on the 18th, I prepared to go to the settlement conference because I did not hear from him other than that phone call.
Well, that's a pretty serious phone call.
Yes. And also on the 18th, I made 3 phone calls. One of the phone calls, well, actually, I listened to my voicemail. That's when I got the message from Mr. Price. And also on the 18th, I called Mr. Price at the phone number he used to have, and it reflects on here Bremerton, Washington, because he lives near Bremerton, Washington. I also called and I informed him, if I don't hear from you within the next hour, I'm not going to go to the settlement conference.
He already discharged you on the 17th, sir.
He did. I was trying to give Mr. Price another opportunity.
That's your problem. Mr. Price discharged you effective the 17th.
Yes, I understand.
So I want you to tell me, you know, lawyers who are charging by the hour,
right,
Mr. Belmer, and you are charging by the hour because you didn't have to have an hourly rate. You could have had a fixed rate. You could have said, listen, I'm going to charge you $1,500 to do your domestic violence case, and then I'm going to charge you $5,000 to do your matrimonial case. That's my flat fee. You chose to do it by the hour. Well, then you have to justify your hours. How could you come to court today without justifying your hours?
Your Honor, when Mr. Price and I signed the fee agreement, one of the things that Mr. Price was concerned about was the fact that it would be more than $3,000. So I agreed with him that it would be no more than $3,000, and I wouldn't have charged him any more than $3,000.
Listen to me, sir. You're a lawyer in the state of Washington, and I'm certain the state of Washington has the same laws of most of the other states in this country, and that is, when you have a written contract, anything that you say is within the 4 corners of this agreement. If Mr. Price said, well, we had an agreement for $243 an hour, but after we signed this agreement, he said, I'm only going to charge you $100 an hour, you would laugh in his face, and you would say to me, Judge, you know he can't say that. We have a written contract for $243. So what you as a lawyer are trying to say to me, that you orally changed the terms of this written agreement by saying I'm not going to charge you more than $3,000 when this contract says nothing about that?
No, I did not change the terms of the agreement, Your Honor.
Well, then show me where it says that the maximum fee will be $3,000.
It doesn't say that.
Of course it doesn't say that. Can you account for any more by showing me a ledger, a log, anything prior to the 17th of April? If the answer is no, then it's a very easy case for me.
Your Honor, if I may.
You can show me a ledger. That's what a lawyer does. A lawyer who's charging by the hour keeps a record. April 2nd, 1.5 hours, phone and writing up complaint. April 12th, court with client. April 5th, coffee shop. Prepare the client for deposition. 1 hour. That's what a lawyer does who's charging by the hour. It's the most ridiculous thing I ever heard.
Your Honor, if I may make a statement. At the time Mr. Price discharged me, his statement, as I indicated earlier, is, I never want to hear from you again. I have on my computer a bill in draft form for Mr. Price. I didn't bring the bill today because Mr. Price didn't ever want to hear from me again. And frankly,
$2,400, judgment for the plaintiff. That's all. Step out.